Deputy Registrar, could you please open the proceedings?
Good morning, Justice Witt. Thank you. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Barbados, hearing of appeal in CCJ Appeal BBCV number 3 of 2022 between Larry Pierre Tatem and Katherine Tatem. The members of this morning's panel are Mr. Justice Witt, presiding judge.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnath Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning, Counsel, and forgive me if I go non-visual because I'm having some connectivity problems. So if you see me missing, I am still present.
Thank you, Judge. And Mr. Justice Jamada.
Good morning, everyone, and I may fall into similar circumstances as our brother Justice Barrow, but will be present throughout, if not always visible.
Thank you, judges. May we have the appearance, please? Thank you.
You're on mute, Mr. Weeks.
I am sorry, my lord. My name is Brian Weeks, and I appear in this appeal on behalf of the appellant, Mr. Tatem.
Good morning. Marguerite Woodstock Riley, in association with Amanda Riley Jordan, appearing for the respondent, Katherine Tatem.
Okay, thank you. Ms. Riley, we understand that your client is quite ill, correct?
Yes, my lord.
Okay, but anyway, we nevertheless decided to sorry.
Mine has been ill. I think it's Mr. Weeks.
Oh, Mr. Weeks is clear.
Yeah,
oh, sorry.
yes, he has a very severe case of gastroenteritis, Your Honor. So he is not doing well at this point.
No,
but he's anxious to have the matter dealt with. So
well, I can imagine that everybody is anxious to have the matter dealt with.
Yes, ma'am.
In some way or another. Yes, I do seem to recall that at some earlier session, because we have already had many, there was some discussion about maybe trying to settle this, but apparently that has not succeeded.
The parties have not come to an amicable settlement at this point in time.
Okay, so what we are talking here now, in fact, this is going on for 10 years now, which is rather shameful, actually, because they started with the interim consent order of the 22nd of January 2013. There was an application to vary that order, but that was dismissed. And so we are talking in fact about the enforcement of that interim order, correct, Mr. Weeks?
We are, yes, Your Honor.
Yeah, and according to that order, well, a certain amount had to be paid by your client. And we know that, okay, he did make some payments, but I gather that there is still an imbalance that needs to be paid. Is that correct?
Well, Your Honor, that is one of the issues raised on the appeal, because you would have noted in my written submissions of the appellant that the order under appeal had two distinct parts. So there was a liquidated part which mentioned an actual sum. Yeah. That element has been paid in full. We say, however, that the remainder of the order was not specific in any shape, form, or fashion in terms of an amount, when it was to be paid, or to whom, and that in the underlying High Court matter and in the Court of Appeal, we maintain that by virtue of the method of enforcement which has been selected by the respondent, that is a live issue on the appeal, because we will contend on the substantive appeal in the fullness of time that there was insufficient evidence before the High Court to prove the amounts which the court found to be owing. So we cannot concede that there is any amount. Well, there as a pure matter of common sense, there would be an amount, possibly. We just simply don't know to what degree there is adequate evidence to prove that amount.
Okay.
So that is the real nub of one of the nubs of the matter.
Okay, I understand that. Now, the Court of Appeal ordered in 2019 that the case should go back to the High Court for the final maintenance order. The last thing we know, and that application was filed on the 13th of December 2019. What we were told at some point is that that application was going to be heard in October last year. So the question is, what is the status of that?
The status of those applications, they are set before a High Court judge, the original judge, Mr. Chandler, and that matter is taking the usual course of discovery and disclosure so that both parties fully understand the other's current position, so that the court can make final orders disposing of the matter. So that matter, deadlines have been set, a schedule has been set, and therefore that aspect of the matter is proceeding.
Okay. So that is the situation there. So now
President, if you would just, Mr. Weeks, have you all been given a window for a trial? You say it is proceeding and that you all are doing discovery. That sounds good, but surely have you been given a specific window or date that the hearing of this will take place, for example, in April, in May, in June?
In short, no, my lord. The High Court judge has set deadlines for the discovery. I suspect that when we return to Mr. Justice Chandler, I believe it is in March. My friend will correct me if I'm wrong. I believe it is at that time the court may then set a date to have the matter disposed of at a trial.
If I may, it's the 21st of March.
Yes.
But I just want to be clear that the arrears is something separate. The arrears and the amount that we're talking about is up to 2019. So what would be, and we have appeals outstanding in that regard, what would be before the High Court judge is with regard to anything going forward?
Yes.
Yeah, I wanted to ask Mr. Weeks, if I may, Chair,
Sure.
about the amount which you say, Mr. Weeks, you said the liquidated part that has been paid in full.
Yes,
what
ma'am.
has not been paid is what you query, and you say, look, insufficient evidence, whatever else is your case. But what is that amount that was worked out by the judge? Worrell J?
$273,000.
Okay, so that is the sum that we had in the matter, and that you argued in the Court of Appeal there should be a stay.
Yes, ma'am.
With regard to that sum. Okay, and you say with respect to that sum that it could not be enforced because there was no order specifying the amount or saying to whom the money should be paid and so on.
Yes,
Does Mrs. Woodstock Riley agree, not that it couldn't be enforced, but that there was no specific sum, or there was no person to whom that sum ought to have been paid?
As I understand my friend's case, and I don't want to in any way misrepresent her position, my understanding of the respondent's case in the High Court was that those sums had been indicated to the appellant from time to time, and that they should have been obvious. If I may say, ma'am, the position that is being taken by the appellant here is not so much the fact that those sums are not calculable at some point with the requisite evidence. What we say is that because of the state of play, the choice of enforcement, the type of enforcement, which is a committal to prison, is what is in real issue here, because there were other methods of enforcement available, even under the application which was before Mr. Justice Worrell. So the real issue here is, given how that order was drafted and the evidence that was put before the court, those two issues combined, we say on appeal, would render the decision of the judge to impose the type of order which he did not in accordance with the law. So those are the issues in a very tight nutshell, my lady, which would concern the Court of Appeal on the hearing of the substantive appeal.
Ms. Riley, could you just react on that, so that just on this point?
Yes, my lord. The amount of 273 was clearly calculable. It wasn't that it was sent monthly and within the record, and I can point to it. The amount was calculated to October 2019. So the first amount was taken out and the 273 was the balance. That was sent monthly, and it is within the record as to how that was calculated. As Mr. Weeks says, his argument, certainly to the High Court, was not on the amount. I don't see that it can be argued that it was not shown, was the point that if it wasn't a specific figure, it can't be enforced by imprisonment. And I would also just point out, when we say the type of enforcement that was selected, there was no other enforcement available to Mrs. Tatem. He said he was not earning, there are no assets. So the Family Law Act, and that certainly is the first method, if there was an asset that could have been seized, or if there were earnings that could be garnished.
But Ms. Woodruff, pause a minute. It's not what the appellant says, it's whether there are, from your point of view, assets that can be pursued for enforcement. I think you have been consistently saying that this appellant has the capacity and means and assets to pay this and any for future orders. So why do you say they can't pay, and so this was the only method of enforcement? Do you have evidence that of assets or income that are realizable, garnishable, or whatever? There are many methods of enforcement to recover the $273,000 calculated based on the interim order that is due and owing based on the interim order.
My lord, there are no assets that have been identified. What we have consistently identified is earnings. But when we identify, it's not an employed person. When we identify, for example, that he was paid 300 and something thousand from Rubis, he's already paid it. On every step of the way, we have identified what he has earned. So it is not simple, and it certainly would have been our first option if we had the money that we could then seize. We are always one step behind. So we've shown what he earned from this company, from that company, but we are behind the ball. So our position is that he has had the money. We don't know where it is. And therefore we've asked for the order for him to pay it. We've shown he has the money. We don't know where it is. And we've consistently done that from Justice Chandler through third-party discovery, TD Reinsurance, Gildan, Sheffett. We did all of that in the Chandler matter. Then we did it again in the Worrell matter. But for example, his work in St. Vincent, we say he worked there. He said he made $5,000. The immigration officer was able to show us that he went every month, but we don't know what he earned. So it is not simply, we can identify where the money is, we can show that he earned it.
Okay.
Well, just on that point, I wouldn't want it to slip later on in the in my presentation to the court. My friend, what I would want to point out to the court is that one issue which has escaped the High Court and the Court of Appeal, unfortunately, is that Mr. Tatem, as a professional architect, operates sort of a corporate entity. It is called Tatem Architects, Inc. Now, that is a VAT-registered entity. Mr. Tatem, in an affidavit which was filed before Mr. Worrell, voluntarily placed every single bank account statement of account from Tatem Architects, Inc. before the court. That information was before Mr. Justice Worrell. Mr. Justice Worrell would have seen, had he managed to go through it or allowed a proper hearing, as that's another point that I will come on to, he would see that all of the fees that my friend references would be disclosed in those bank accounts, but bank account statements. What the court in the High Court failed to understand, and what Mr. Tatem tried to explain, was that you can't simply look at revenue. It is a business. Businesses have income, they have outgoings, they have all sorts of professional obligations and so on. So it is completely inappropriate to simply look at a course of revenue and say that an individual who works through a corporate entity, which is VAT registered, it has corporation tax liabilities, it has all of these things, to simply look at revenue and come to a complete position, to a decision on evidence beyond a reasonable doubt, because this is a point that I will get to a little bit later in my presentation if I'm allowed to get there. We say that we have voluntarily put every scrap of evidence in terms of what in terms of money earned by the company before the court, which has been ignored. Now, my friend says that there was no other way of getting information. We take umbrage with that, because from the very beginning, and one must note that this enforcement proceeding was filed in 2013, almost at the exact same time that the original proceedings were filed. So that at any given time, Mrs. Tatem would have been entitled to all of the information for Tatem Architects, Inc., all of the bank accounts, all of the billings, all of that information before the court, and she could have gone to the court for a freezing order, freezing the monies in those accounts as a spouse who would have had an interest in the shares of Tatem Architects, Inc. So there were mechanisms available to Mrs. Tatem at all material times if she was confident that there was something untoward going on. Now, I want to make one point very clear. In my submissions, I don't know if I put them in these submissions before this court, but they were certainly before the Court of Appeal, that when you tallied all of the income gross, before you took anything out for VAT, corporation tax, any of the other things that you would expect, the amount gross was just over $1 million for the entire period of time. Now, when you compare that amount of money, which has been voluntarily disclosed by Mr. Tatem, and you look at the amount of money that would have been generated by the order in a global sense, it is more than half of the gross amount of money which would have been deposited into the accounts of Tatem Architects, Inc. We say these are all relevant matters which the High Court judge ought to have taken into account before he could come to a decision that Mr. Tatem at all material times would have had sufficient money to properly pay this maintenance order. And this is why we want the opportunity at some stage before Mr. Tatem is locked up to be able to argue these matters fully and thoroughly before a Court of Appeal, because on the record that was before Mr. Justice Worrell, even in the procedure which he adopted, which we say was not the correct one, it should have been obvious to the court that he could not come to a decision beyond a reasonable doubt, because that is the standard here. This is a form of committal, and the law is very clear that the court must be satisfied beyond a reasonable doubt that Mr. Tatem had all material times this money, and every single time he was about to, he needed to pay, he didn't pay. This matter.
Mr. Chair?
Yes. Yeah,
I'm sorry. As you know, I am fairly new to this matter, and the background is very, very interesting, no doubt. But I wonder whether so far we are focused on the issue that is before us, which seems to me to be a fairly narrow issue, Chair.
Yes,
I don't know whether you plan to shepherd us in that direction.
I was about to do that.
Thank
of course, the context of the narrow issue is also important,
of course,
to look at. But anyway, the arguments that you are now put forward,
yes,
those are the arguments I gather that you would have wanted to bring forward in the appeal that was not heard yet.
Yes, Millard. And the only reason I do that, Your Honor, is because one of the things that we must demonstrate to your satisfaction is that the Court of Appeal itself did not give sufficient weight, or it didn't pay attention or sufficient attention to one of two things: the strength of the underlying appeal, and two, the effect of the order on the appellant. So one of the things that we must show to your satisfaction is that the Court of Appeal's discretion must fall because they have erred in principle in some way, or failed to appreciate some element of evidence or something of that nature. We can't simply come to you as a final court to say we don't agree with the Court of Appeal, therefore you must set aside what they've done. And this is why it is incumbent upon me, I think, to be able to demonstrate as forcefully as I can the strength of the underlying appeal. And in that regard, my lads and my lady, I reserve or I rest to a large degree on the written submissions, because I think I've pointed the court in the direction where the law needs to be investigated. And I say that for this reason.
Mr. Weeks, just to cut across you. So on the strength of the appeal, your starting point is rests on A, burden and standard of proof. In other words, the strength of the appeal in relation to the stay, which is discretionary, you say because this was an application that would have culminated effect with a possible incarceration, which that was the order that was made, that because that falls into that bucket, so to speak, the burden of proof was on the appellant throughout, and the standard of proof was beyond a reasonable doubt. And so your argument is, I'm asking, so is your argument then that the Court of Appeal erred in that it has not demonstrated that it either understood or reasoned along those lines?
Yes, Millard, that is one of the arguments that I present, but it would not be the appellant that has the burden of proof. It would be the respondent.
No, the respondent. I mean the respondent. I mean the applicant. The applicant yes. For the order.
Yes.
When I say, did I say appellant? I meant applicant. The applicant, yes. The person seeking the contempt. The burden is on that person, and the standard you say is to beyond a reasonable doubt. And your submission is that the Court of Appeal has not demonstrated in its reasons, that is Narayan J.E., that it approached the case in this way, and therefore it fell into error. I'm just trying to summarize for my clarity your submission on this point. Is that correct?
That you are absolutely correct on that point.
Okay, Mr. Weeks.
So, Mr. Weeks, if I may.
Yes,
sure.
Is there anything apart from the absence of any statement? Is there any shows that the Court of Appeal failed? Is there anything which shows that the Court of Appeal applied the wrong standard?
There is nothing which expressly shows that they applied the wrong standard, because the reasons, as I understand them, that have been provided are very brief reasons, and the reason actually given was that the Court of Appeal had already weighed in on its view of the appeal generally from a previous appeal, which was number 8. And we say, in addition to what my...
No, Mr. Weeks, I quite understand that. I quite understand what they did. What they did was to say, listen, sorry, are you hearing me?
Yes, we are.
Are you hearing me, Mr. Weeks? Yeah. Yeah. What the Court of Appeal, as I understand it, was to say, listen, in civil appeal number 8 of whatever it was, we dealt with this matter substantively. We went through this fully. What is now before us with this new application is the issues are essentially the same, and we have already dealt with this, and as it were, we reiterate, we reapply what we decided then. Yeah?
Well, Malad, in so far as the Court of Appeal purported to refer to the previous appeal number 8, that appeal substantively has not been argued either. They had a similar application for stay before them. So so no substantive appeal arising out of Worrell J's orders.
Oh, no, but they dealt with a stay in civil appeal number 8, and they were dealing with a stay in civil appeal number 24.
Yes, ma'am.
So two stays.
So,
and what said was, in this latest stay, we are informed by what we have already seen and what we have already decided, and having considered what is involved in the application stay presently before us, be as it were, no reason for granting a stay. This appeal is hopeless. And you're saying they went too far.
They went too far in that regard, but they also erred in a different way, because they didn't appreciate that the grounds of appeal in number 24 are substantially different to the grounds of appeal in number 8, because it's a different part of the order that is being appealed and for different reasons. So they didn't realize
Mr. Weeks, I'm grateful again that you have raised that, because let me tell you what is engaging me, and I really do seek your assistance. I get the impression that they were taking a broad view.
Not hearing you.
We're not hearing Mr.
The 4th of November.
Maybe if you took off your video for a moment, Justice Barrow.
I think he's now frozen, Justice Witt, so we may just have to.
Yeah, this is not a consequence of a freezing order, but it seems that Justice Barrow is maybe we have to ask him to rejoin.
Yes. Until Justice Barrow rejoins, I just wanted
Hello?
to.
Sorry.
Yeah.
Yes.
You're back.
Maybe you should take off your video. Try taking off your video.
Yeah.
Yeah,
Yes, my video is off, and I am on my phone.
And we are hearing you.
Okay, Justice Barrow, you can speak. I think you're now muted. Yeah.
Yeah, hello?
Yes, we can hear you.
The application filed on the 4th of November 2020 was essentially Mr. Tatem saying, I can't pay. And the Court of Appeal, as I understand it, took the view that, listen, we have already heard this in civil appeal number 8. You're saying the same thing in this application. We have been through this. Yeah, tell me if I'm wrong there.
Well, globally, that would have to be the position that the Court of Appeal took.
But was there something wrong in that position?
Thank you.
Yes, and the reason that there was something wrong in that position was that the Court of Appeal failed to appreciate, we would argue, that the part of the order to which number 24 applies raises different legal issues which were canvassed on the grounds of appeal in number 24. So that we say that insofar, if they took the view that, those appeals were hopeless, they were wrong. Because the law, we argue, is definitely, the appeal is definitely at least arguable given the state of the authorities on that element of Mr. Justice Chandler's order and the way that it was drafted.
Mr. Weeks, what
Yes,
were the
ma'am.
different, just articulate first at this point, what were the different grounds?
Right. The different grounds are, one, that the judge did not have the jurisdiction to make a second order for contempt on the same application. So he was, and I made that submission to his lordship at the time, saying that as far as I understood the law, the court came to a finding of contempt and was obliged to make an order once and for all, and that the court was not entitled to make one order, see
All right,
what happened.
Pause. That's the functus argument.
Correct.
But Justice Narayan dealt with that, didn't he not?
He dealt very briefly with that.
No, I know. Forget about brief. Forget about inadequacy for now. We're not talking.
Right.
You said to us that the Court of Appeal, you said in answer to our brother Justice Barrow,
Yes.
that the Court of Appeal did not deal with issues that were different that were raised in number 24. The first one you raised is what I have called the functus issue. You are now agreeing, I mean, not an inadequacy of reasons beyond whether they dealt with it.
Right.
Justice Narayan, and I accept in one or two sentences, dealt with the functus issue and said there was no merit. Is that not correct?
That's correct.
All right. Okay.
What the court did not, however, from my studying of the transcript, they did not realize that we're also saying that because of the order as drafted, the fact that it did not have what was required in terms of amount to whom and when these amounts should be paid, that type of an order in its very general state could not be enforced by way of contempt of court and imprisonment. Those are grounds. Yes,
Mr. Weeks, we understand what you're saying. Are you saying that in the previous application which the Court of Appeal dealt with, they did not deal with that issue?
No, ma'am, they couldn't have, because the events that led to these arguments being relevant would not yet have happened. Because the second order, we appealed the first order before the second order was made.
So just going back to the earlier application then, so when Justice Narayan, Justice of Appeal Narayan says, look, these substantive issues were issues which we rejected wrongly, you are saying this is not one of those issues.
That's exactly what I'm saying, ma'am.
I just wanted to get that clear. Thank you.
Yes.
Okay, do we, the decision of the Court of Appeal in number 8, do we have that decision?
Yes. We sent that decision to you. As a matter of fact, we appealed to the Caribbean Court of Justice on that one.
Yes.
And your court said, look, we're not going to interfere, because by that time the money had been paid, so it was rather an academic argument, quite frankly. So that really and truly, why we say that the Court of Appeal erred, the most fundamental point is that there are issues arising on this appeal, genuine issues on this appeal, which they could not possibly have dealt with previously. Save and except that Mr. Justice Terrain, as Mr. Justice Jamanar said, did raise, even if peripherally, the issue of the functus argument. So there are matters on this appeal that were not on the previous appeal.
I thought you were in the process of enumerating what those matters were.
Well, I guess, yes.
I think what struck out on one, and a second one is pending. But what are the other matters you're saying that were not considered by the Court of Appeal?
What was not considered in the round, the issue of the the actual order itself, how it was drafted and how it was presented to the parties, we say as a matter of law that order, that type of order, cannot be enforced by virtue of contempt proceedings where there is going to be a committal of the individual. Because in order to be locked up, because committal is a form of quasi-criminal, or in some judges consider it to be criminal, where you're going for imprisonment, you have to know the details of the order which you have been, it is alleged that you have breached. And we have cited the case law in our written submissions that say you can't do that. You have to be very, very careful if you're going for imprisonment to have set out in the order that started it all with precision exactly what the contemnor was required to do. And we say that.
All right, so Mr. Weeks, pause. Even if that is the law on it, but you are saying fundamentally that the Court of Appeal did not even address its mind to it. Forget about the merits of the argument for now, whether we think that argument has merit or not. Forget that for now. You are saying the Court of Appeal did not even address its mind to that issue. Is that what you're saying?
I am saying it, and I'm saying that.
All right, pause. Where in your grounds did you raise that? You've articulated something to us. You've told us something here now. I want you to go to your grounds and show us in your grounds of appeal where you raise what you just told us. And the nub of this thing is before you can come for penal, you must have the penal clause, you must have, the order must be on the face of it specific, correct?
Yes, Milad, that is precisely the point.
It's not a new point, but what I want to see is really, you say that they did not address it, all right? You are raising it now. Show us where you raise that in your grounds. Because if you are going to criticize the Court of Appeal for having not addressed it, what I want to be satisfied about is that you raised it before them. Now, it may be that it was in oral arguments, fair enough, I don't know, but let's start with the grounds. Is it in your grounds? If so, where? If it is not, what you're telling us, did you tell them? And Ms. Woodstock, if not now, at some point, I want to get a very specific answer to what I've asked, please.
Yes, my lord.
I'm actually looking for the notice of appeal. I do crave your court's indulgence. My file. Yes, here we go.
If I can be of assistance, in terms of in his appeal in 24, it is the second ground that it was lacking in sufficient particularity. What we would say that was raised in number 8 and was, sorry, sir, you're mute.
Yeah, no, I don't want a contestation on merit. I just want to make sure it's in the grounds. So it was in the grounds, right, Mr. Weeks? Is that right? Is it ground number 2?
I'm looking, the grounds before the CCJ, Milad?
No, before the Court of Appeal.
Yes, Milad. Yes, Milad.
Ground number 2, right?
Yes.
And
in which matter? I'm sorry, Judge. In which matter?
Number 24.
Number 24.
The notice of appeal in number 24. I don't have it before me, but what we are being told is ground number 2 in that notice of appeal articulates what Mr. Weeks is saying to us. And you presented oral and or written arguments on this to the Court of Appeal, Mr. Weeks?
Yes, Milad. Yes, Milad.
And Justice Narayan doesn't deal with it.
Well, not in his not what he says on the record. No.
Yeah. Mm-hmm. And was this raised in number 8? I know your answer is no. This is for the record. This could not have been raised in number 8, you say, but I just want to be clear. It was not raised in number 8.
Well, before I misspeak, I would want to refer back to number 8 because it would have been a relevant argument even before Justice Worrell, the original hearing. So before I say
That's
something,
what I would have thought.
what I can say, Milad, to save time, is that the specific order, which is under appeal, the $273,000, which was assessed by Justice Worrell.
No. That's a little bit of a walk around. Sorry. You are on the principle of it, because we see what we know is Justice Narine says that, look, we've dealt with these issues before. That's what he's saying. So we're not going to repeat it. You got, as Justice Anderson nicely put it, struck out on one. The second one you're on now is that, hold on, they did not deal with an issue that was in 24 that was not in number 8, and that is the specificity, if I can call it this, the specificity of the order point, right?
Yes, Milad.
If you're going to come for contempt because it's quasi-criminal, the order that grounds that application must be sufficiently clear, cogent on the face of it. Okay, we know the point. But your big point is it wasn't raised in number 8.
Yes, Milad. I found the grounds of appeal in number 8, and nowhere on these grounds is the issue of the particularity raised. Okay. So I can say I've just looked at the digital filed version on my system. That issue that we're discussing now was not frontally raised at all on the notice of appeal. In
Good. All right. So that's number 2. You haven't got struck out. Number 3. Any more?
You've lost me, Milad.
Your first point was the functus.
Yes.
You got struck out.
Correct.
By agreement, you accept. Second point is what I've called the specificity or the particularity of the order point.
Correct.
You have said, you showed us where it is in the grounds in number 24. It's not in the grounds in number 8.
Correct.
Any other points that the Court of Appeal that were raised in 24 that were not raised in 8 that the Court of Appeal did not address?
No, Milad, that would cover the difference, the fundamental difference between the two appeals. We say they raise similar issues, but those are the additional issues in number 24.
Good.
Can I ask my brother, Mr. Damara, if I may? Can I ask you began by saying that you rested your appeal on the strength of your appeal, was really about the burden and standard of proof, those issues. Did the Court of Appeal deal with those issues, Mr. Weeks, in 8 of 2020?
Milady, what they from memory in number 8, the court looked at the pleaded appeals in a round and came to the conclusion that in its view they didn't have much prospect for success. They didn't descend to particularity as to how they thought the appeal was weak. They just came to the conclusion that that it was weak and therefore they would not be issuing a stay. As a matter of fact, before they got to that, there were competing applications for enforcement and various other things as well, which were engaging the court's attention. So, but in answer specifically to your question, there was no precise, discrete treatment to those issues by the Court of Appeal.
But they were issues that were argued before the Court of Appeal.
They would have been, yes, ma'am, because we raised the whole argument of the Debtors Act and all of that before them on those grounds. So they would have, one would hope that they would have taken them under advisement. And even if they didn't come to they didn't descend into particulars, they formed a particular view of the law at that stage without hearing full-throated, fully ventilated and briefed argument on the issue.
Yes.
Is it your point that are you saying that the Court of Appeal should not have taken a decision on the stay without hearing the appeal? Is that what you're saying?
No, Milad, what we were saying is that the Court of Appeal and this is where the delay point becomes relevant. The parties in this case, unfortunately, were faced with a situation where there was a live appeal and an application for a stay of the order under appeal, where there was neither reasons nor transcripts of the actual proceeding.
Correct.
So the Court of Appeal was really put, quite frankly, in an invidious position to do the best that it could in the circumstances. Now, we say that given the state of play and the length of the delay that we were encountering at the point in time when the Court of Appeal did entertain this application for the stay, I don't think the Court of Appeal had any choice, and this is why I volunteered, as my friends pointed out, on the stay application. Look, the Court of Appeal has to deal with this matter even in the absence of reasons and or a transcript, because the court should try its best to form its own view of the appeal which is before it substantively. We didn't agree with how they treated to the issue, but the Court of Appeal, to its credit, grasped the matter by the horns and proceeded to deal with the matter. And here we are. So that basically is what
they
happened.
proceeded with the matter of the stay.
Correct.
Yes, but still the appeal itself has not been heard.
No, Milad. Now it has not been heard, and I know my friend takes a position on her written submissions that there's no need for reasons and so on. Even if that were true, which we don't accept, this is a rather peculiar case because we don't have the transcript of the proceedings. So this is not a situation only where there are no reasons. The Court of Appeal can't see for itself what actually happened and what questions were asked by the judge and how the responses were given by the witness, Mr. Tatem, and so on. So this is not like the cases which have been referred to or cited, because in all of those cases, save and except the one on stays which the Caribbean Court of Justice dealt with, I believe it was the Rodriguez case, which I mentioned in my argument. Almost, well, I would say every other case I've read where there were no reasons, there were notes of evidence. There was something that the appellate court could look at to determine whether or not it should intervene, make a decision of its own, send it back for rehearing. The problem that we face here, the challenge that we face here, and the Court of Appeal faces, is that there's not even a transcript. There are no notes of evidence.
Is that normal in Barbados, or is it exceptional?
I would say I have heard in my many years of practice, I can't say that it's never happened before, but it is rare.
Mm-hmm.
Very, very rare, particularly, my lads. And you know, the Court of Appeal, even though we've appealed their decision, they, to their credit, have done everything they can. They've ordered, you know, the registrar to provide the transcript. They've ordered that she write to the judge for reasons. There's nothing more that the court itself could do, mm-hmm. quite frankly. And
Mr. Weeks, pause for a minute. You say the registrar has ordered, or the Court of Appeal has ordered through the registrar, to produce the transcript. And the registrar has not produced the transcript. As a question of fact, has the registrar given an explanation? Because the non-production is one thing, but is there an explanation, for example, to say there is no transcript, the audio recordings failed?
As a matter of fact, Mr. Justice Ramad Jamadar, as the court is aware, the delays here prompted Mr. Tatem to file a constitutional motion predicated on the very issues which we are now discussing. And I can say to you that my friends on the other side have appeared in the matter. I'm holding a watching brief in the constitutional matter, and counsel for the state have been unable to respond because they've not been given any information to date from the powers that be to file a response to the constitutional motion as we speak. So there is a breakdown somewhere in the system.
I don't want to object. I have been holding on, but I do object to giving evidence that's not before the court.
Well, as
far as I know, they were given a time to respond and that they were working on that response. But well, I don't want us to start giving evidence on either side on a matter that's not before the court.
But anyway,
Because
what
that
is
is
before the court is the fact that there are no reasons after 3 years, and there is no transcript. That is a fact, correct?
Yes, my lord.
And that is well, that is very worrisome, to say the least. Okay,
Yes.
whatever the effect is of that is a different matter, but it is something to deplore. Anyway.
Yes, my lord.
Yeah.
The
Yeah, if I may
Mr.
ask, if I may ask Mr. Weeks, Mr. Weeks, you were going through and you had presented two issues. I took you to a third, which is the burden and standard of proof, and so on. You said that the court heard arguments on those matters in 8, and they ruled that there was, I take it, no prospect of success. You mentioned a short while ago as well a matter which you tied into your second issue, which is, as Justice Jamada aptly calls it, the specificity of the order point.
yes,
And you
ma'am.
tied into that the insufficiency of evidence point. You
Yes,
said there
ma'am.
was did that matter arise in the previous matter? And were there arguments before the Court of Appeal on that matter?
Ma'am, that would have featured prominently in number 8, because what we were saying is that the court, and what we were saying in number 8 was principally two things. One, that the wrong procedure had been employed by the court incorrectly, and that 2, even if the correct procedure had been employed, there was insufficient evidence before the court to come to the conclusion which the judge did. Those were live issues in the appeal of number 8. There's no getting away from that. Those were issues which the court, we assume, would have taken on board and can't come to the conclusion which it did. But I do want to add one thing, though, my lady, is that in number 8, by the time the Court of Appeal would have dealt with that issue, the actual effect of the order under appeal would have been rendered academic, because the monies would have been paid by Mr. Tatem. So that, and certainly by the time it reached the Caribbean Court of Justice, the monies would have been paid. So the urgency of the appeal in that regard would not have been what the urgency would have been somewhat relaxed, I think is a good word to use, as opposed to number 24, where the order until stayed by the Caribbean Court of Justice was actually live. So that is just one distinction that I would want the court to bear in mind when it comes to considering its decision.
So to be fair to you then, Mr. Weeks, is it then that second issue is the only issue, in your view, that the Court of Appeal has not dealt with?
The Court of Appeal has not dealt with two things, ma'am. One, the specificity argument. And the other argument about the oh my goodness, I've lost my train of thought, man. But there is
okay,
the
take your time and come back to it, because we would need to hear. The first one we have, the second one.
It was the specificity argument.
Mm-hmm.
And then the other argument would have been, it seems as though I need to take my Prevagen, ma'am. It's just flown completely out of my brain. I do apologize.
Okay, look at your papers, Mr. Weeks.
Yes, man, that's what I'm trying to do now.
Mr. Weeks, maybe we can remind you the functus issue you raised with us.
Correct.
The specificity of the order issue you raised with us.
Yes.
The insufficiency of evidence issue
Correct.
we just explored.
Yes.
You raised the burden and standard of proof. My understanding on that may be a little different. I don't know, but I thought you were saying that it was not dealt with expressly. This is my note by the Court of Appeal in 8 or in 24. It is relevant in 24 because we are saying in contempt, because it is quasi-criminal, burden and standard of proof is very relevant to any analysis.
Yes, ma'am. Yes,
so
sir.
what you were saying is you because the same thing with because the contempt thing was raised here, that is relevant. So those are my notes. I don't know if that's what you're searching for or not.
You've captured it, but there's one other matter that I would just want to canvass very briefly. To be fair to the Court of Appeal and to Mr. Justice Worrell, the the effect of the decision of the Caribbean Court of Justice in Severin versus the Queen, where the existing law clause was, the effect of the existing law clause in our Constitution was changed. Until that decision, what would have occurred in this matter would not have been open to the type of challenge, or one of the challenges which I'm hoping to make, because the procedure set out in the Debtors Act was expressed in the statute itself. Our argument on the substantive appeal will be that as a result of the Severin decision, the provisions of the Debtors Act must be now read against the requirements of the Constitution, and the analysis of that issue that is set out in the English Court of Appeal cases of Preston and Mubarak and those lines of cases now render what ought to happen very different from what pertained before. So that is an issue which we hope to argue on the substantive appeal when and if it comes on in the fullness of time. So I just wanted to make sure that the court was fully cognizant that that is a very important area of the law which we intend to canvass in the Court of Appeal, and who knows, maybe even then ask your court to resolve it once and for all if that issue gets that far.
And what would be your conclusion then?
Our conclusion, my lord, is that the process which Mr. Justice Worrell employed ran up against the requirements of the Constitution, because the transcript will show that Mr. Tatem was required by the court to take the stand and was actually cross-examined by the judge. That is not allowed as we understand it, or certainly we will be submitting that even if that were permissible before Severin, it is certainly no longer permissible because of the protections now contained in the Constitution and the protection of the law provisions. So that would be the argument in a nutshell, my lord.
So that would then mean that
colleagues,
just one more minute, Justice Barrow. So that would mean, in your view, that there shouldn't have been an order for contempt, or at least no order to go to jail for 28 days, correct?
Correct. And what a court of appeal, an appellate jurisdiction would do, as happened in Mubarak, is to quash what had happened and send it back for rehearing in a proper manner. In other words, to give the contemnor or the alleged contemnor the benefit of the protections that he's entitled to under the Constitution.
Okay. Justice Barrow, please.
Yes, Mr. Weeks, my colleagues have been very interested in a comparison of the two appeals, etc. I'm afraid that my compass is a bit more brief than theirs. And what has engaged me is the application which the Court of Appeal refused and which forms the subject matter of the present appeal before us. I see that the application which was refused, and I referred to it before, was one filed on the 4th of November, 2020. And I pull it up on my screen. It is at page 88 of the record. And the brevity of it, I think, is breathtaking, because it says that what you are applying for is an order staying the execution or enforcement of the order of Mr. Justice Worrell made on the 16th of September. And that is all it says, no grounds or anything. So, sorry, I am wondering as to how much of all that has been discussed can fit into this particular application and the refusal of this particular application. Can you help me there?
I'm not at all. You say the document is referred to at page
88 of the Court of Appeal, the CCJ's record. Part 1 of the transcript. Page 88 of 311.
Yes, my lord. Well, my lord, this is the application. This is the order that is being asked for.
Yes, it is the order that is being asked for, but
no, my lord, but this is in the court of appeal.
For that order that is being
in number. This is not any CCJ, my lord. This is the application.
Sorry, I lost you there.
This is the application in the Court of Appeal, which was turned down.
Yes, I know. Right. And you are appealing to us against a turning down of this application.
Yes, my lord. This application was supported by
the totality of this application. I know.
Well,
but
there was
the affidavit does not provide. So, what's that?
Well, the affidavit, the stay of this application, my lord, let me just put it this way. No objection was taken either by the Court of Appeal or my friends on the other side at the hearing of the form of the application, which was before the Court of Appeal. So it was very clear.
Which is your great, Mr. Weeks, that is to your great good fortune, and I'm happy for you. But in terms of where it puts us, there is a question as to what is the substance of your appeal to this court against, as you put it, the turning down or the denial of that application to which I've just drawn your attention. I have listened with good interest to the various strands of arguments which can be developed in relation to the process, what will take place on the hearing of the substantive appeal, what arose in number 8, and what arises in 24, etc. All of that is, is out there. But I think, as I'm indicating, what engages my narrow little mind is how can these things help you in relation to this application, which you filed on the 4th of November. So as I said, I'm troubled.
The only response I can have to your query, my lord, is that the matter of what needs to be considered by a court on an application for a stay of execution and or enforcement is a matter, first of all, of discretion, and two, very well established by the requisite and very long-standing authorities. There are two things, quite simply. One, whether or not the appeal has a good prospect of success, and two, whether or not what is the effect of the order on the person applying or the party applying. Now, on its face, the evidence which was put before the court in the Court of Appeal on the hearing of this application, there was significant evidence of what happened or transpired in the Court of Appeal, and the issues as raised on the record before the Court of Appeal on a transcript, canvassed and in written submissions, canvassed the relevant considerations, so that even if the notice of application on its face may be argued was perhaps deficient, which I don't concede, what happened before the Court of Appeal, both sides filed submissions and both sides argued their cases fully, and the Court of Appeal made its decision. So that is the only way in which I can respond to your lordship's query in relation to what was actually on the notice of application before the Court of Appeal.
Oh, okay, I am very grateful for that. And then just one follow-up question. I look now at your notice of appeal in these proceedings flowing from that refusal. There are 4 grounds in your notice of appeal. The proposed grounds are the court fell into error because it ignored the order for the urgent hearing and failed to give importance to the fact that the appeal could not be heard absent the record and transcript. 2, that the court wrongfully exercised its discretion given the penalty of incarceration. 3, that the court erred in finding that there was no prospect of success absent any reasons upon which they could come to that conclusion. And 4, that the Debtors Act is open to constitutional challenge. So again, Mr. Weeks, if I may be permitted to just pursue my narrow line of inquiry, I'm wondering, out of those 4 grounds, the Debtors Act really does not impress me. You can bring the constitutional challenge, or you said you have brought that, and that is fine. But that cannot detain the Court of Appeal in relation to not allowing the stay for which you are, right? So then the other matters, none of them really speaks to the merits of the Court of Appeal's decision refusing the stay. Now, you may come back and say, yeah, well, they hardly gave any reasons for which we can challenge the merits. So one can understand that. But again, it is not as if, though your grounds say the Court of Appeal erred in law when they failed to the person who has a net income of X dollars must not be treated as being possessed of the income of Y dollars, which accrues to the company and not to the individual, that sort of thing. But you see my difficulty?
Well, my lord, with great respect to your query, those are really matters. Those are really matters which concern the appellate court on its substantive appeal. What should concern this court is whether or not that appeal has any prospect of success, or as a matter of fact, the case law that I've read says whether or not it is an arguable appeal. That is the consideration on a stay of on an application for stay of execution, not condescending too deeply into the merits of the appeal or the grounds of appeal beyond.
And Narayan said it has no prospect of success.
Well, that is Justice Narayan's conclusion to which he's entitled. And we have come to this court to say that he was wrong.
All right. I have asked my question, and you have to your point.
Much obliged.
Thanks.
Much obliged.
Okay. I think, Mr. Weeks, we have to round off. Is there anything you want to put forward which has not been discussed yet?
No, Millard, I think we've canvassed what I consider to be the relevant matters for the consideration of the court on our application on this appeal. Unless there are any other specific questions which I can assist your lordships and your ladyship with, I rest Mr. Tatem's appeal at this point.
Okay, well, you also have a right to reply after.
Yes, ma'am. Yes, sir.
Ms. Riley has spoken. So if something comes up, you will be able to deal with that. So now I turn to, I think, Ms. Woodstock Riley, yes. Or Ms. Riley. Yeah.
Woodstock Riley.
Yes.
Yes, my lord. I do want to start with giving some background. And I think the factual background is important. And as I said, I did want to object in the between. But the court would see in Justice Chandler's judgment, which is at page 337 of the record of appeal, and Justice Reefer's judgment in number 2 of 27, which is at page 372, an outline of the facts. Briefly, the parties were married from in 1995, and there's one child of the marriage. The wife was a housewife, essentially through the marriage, and traveled with the husband to Canada and then back to Barbados. Mr. Tatem is a successful award-winning architect, and that is also evidenced on the record. One would see if you look at page 200 of the record of appeal, I was trying to make the notes. There are some numbers in blue and some numbers in green. So I'm referring to the numbers that are in blue. Certainly, he's described as an award-winning architect. And the findings of fact, which are not challenged, is that during the marriage, they had a high standard of living. For the duration of the marriage, living in properties worth $4,000, $6,000 a month. They dined out, traveled at least once a year, drove luxury cars, and the child of the marriage was involved in archery, horseback riding, etc. As Justice Reefer notes in her judgment in number 2 of 2017, that it's not disputed the parties enjoyed a high standard of living during the course of the marriage of 20 years, and the uncontested evidence shows the husband earned considerable sums during the marriage, in the opinion of the trial judge, remaining capable of earning considerable sums, and that it was only after the marriage and during these proceedings that it was claimed that he couldn't earn. And that was a finding of fact of the trial judge that it was not so. The other finding of fact is that the wife suffers from a thrombolytic condition, which affects her ability to use her left leg, and it's an impediment to employment. It's also been disclosed that she now has breast cancer, invasive lumbar carcinoma, and she has given her evidence that she doesn't have the financial means to tackle this disease. We also have the evidence that the daughter for whom maintenance was granted also has the gene, and she has not been able to attend university because of their financial situation. But Lord, when the husband left the matrimonial home in December 2012, she made the application for maintenance for the wife and for her child. And as your lordship pointed out at the beginning, 10 years ago. So 10 years ago, Mrs. Tatem came to the court and asked for an order for maintenance for herself and her child. The order was made by consent, and I think it's important to underline that. And the order is also part of the record, which shows that it was discussed, there were changes made to it, and it was by consent. The husband consented to pay these amounts to the wife. Within 3 months, the husband applied, Mr. Tatem applied for a variation, April 2013. And the hearing of that variation proceeded under Justice Chandler. And again, it's important, and it is on the record, because it is there, that certainly Justice Chandler in his decision points out that the hearing of that application was delayed considerably by Mr. Tatem, and that was one of his factors why he granted costs. Costs are not normal in family matters, but he pointed out in his cost decision that the delay of the husband, his refusal, even when he asked for a variation, to say what variation, and his constant adjournments delayed this matter. What is also in the record, my lord, is that, and my lady, the evidence that was before Justice Chandler. So there were affidavits, there were statements of financial circumstances, and that's at the record of appeal I have as 106G. There was cross-examination, and there's the record that Mr. Tatem admitted that he chose not to pay. He chose not to pay when he had the ability to do so. There was discovery by the parties, bank statements, and I note when counsel indicates that Mrs. Tatem could have applied to freeze. We applied for the bank statements and the past bank statements, and we have that is in part of the record as well, and which is why I submitted additional documents. We saw the evidence of the earnings prior to the marriage, 300,000 shown on the bank accounts. By the time we got the bank statements, it was the year before had gone down, and he simply didn't put the money, or the bank statements showed no money. So there was no account to freeze. What we were able, as I said, we're always behind the ball because we were able to show what the bank statements had. By the time we got the bank statements.
Miss Woodstock, that 300,000 is per annum?
Yes, yes, my lord.
And that is the gross sum?
Yeah, well, that's the amount shown in the bank account, yes.
Did you have any evidence of outgoings?
Yes, that is also in the bank statement. And if you look at Justice Chandler's decision, Mr. Tatum admitted that he made his payments from that account. So from that same account where money went into, he would pay laundry, he'd pay the car payments.
Yeah. So what was an audited account done for these statements, as is usual in matrimonial matters that are contested, to do an independent, when I say professional independent, even if one party does it, evaluation of the income and outgoings and to assist the parties and the court? So the 300,000 per annum gross income, all right, but even if not audited, was an accounting statement done to reconcile the evidence you had? Did the court request that? Did you submit that?
It's not my experience that it is standard within the family proceedings. The parties were asked to share discovery. And one of the points, the court and Mr. Tatum was certainly represented by Queen's Counsel. So this was part of the discovery, and this was the one bank account that we did get. And the evidence was that this didn't necessarily disclose all his income. But what the bank account does show, my lord, and the checkbooks, is how money was spent. So this was his operating account. So for example, when we took the point that when Justice Kentish made an order for a forthwith payment, we could look at the bank account and see that he did have the money in it. And we could look at the bank account and see that he paid his rent, he paid for travel, he paid for a car, he paid legal fees.
All right, so just to cut something short, what was on the evidence, summarize for us, please, what was the net disposable income prior to marriage? Because you're saying prior to the marriage, the evidence showed earnings of 300,000 per annum gross from bank accounts and checkbooks, right? What was the net disposable income per annum?
Mr. Tatum filed a financial statement, and I believe it's at page 106 of the record, where he gave his earnings as 180,000.
No, I'm asking something different. I'm asking something different. On an analysis of the evidence that you had, what was his net disposable income?
Well, Lord, again, we are only showing a minimum. And
no, forgive me. I'm not trying to get into the merits, you know. You have chosen to take us through this evidence. You are saying you had this evidence. I'm just asking, you said the evidence showed gross income as well as outgoings. I'm asking a very simple question. Surely, in any matrimonial proceedings, what we do, at least this is my experience of it routinely, is you try to come to a net disposable income figure. You look at income, you look at outgoings, and then you see what is the net disposable income. And then from there, you look at the other payments, interim order.
Sorry, your lordship was breaking up.
Net disposable evidence.
You're breaking up a little bit.
I'm just asking on the evidence that you all had, what is the net disposable income?
I can't say off the top of my head, my lord. What I can respond is that the evidence was provided.
You had an echo in a Please continue.
Yes, my lord. Certainly for us and in the family law court, the evidence is presented. It's a question of establishing a need and establishing an ability to pay. And that was the evidence that was presented to Justice Chandler, and Justice Chandler made a decision based on that. There was discovery, and Justice Chandler made a determination.
The only comment I would make with Woodstock is if you have to determine capacity to pay, I'm surprised that nobody does a net disposable income analysis, because capacity to pay, for example, suppose there's a mortgage installment, suppose you pay electricity bills, water bills, whatever it is. You take income against outgoings, you work out net disposable income, and then you decide capacity to pay. Now, some of the outgoings, I mean, this certainly I know Justice Rajnathli and I sat routinely in these courts, and some people come before the court and they say, "Oh, $500 a month. I have 2 pedigree dogs." They put that in disposable income. We have to pay internet. And a judge sits down and says, well, okay, these are disposable this is disposable, this is in outgoings that are necessary. Some of these are unnecessary. You write that, and that's your reason for saying, therefore, A, B, and C. So but let's move on. Let's move on. You say that
that is exactly what was done.
Well,
yeah,
so
both parties have to file financial statements of what their gross income is. Both parties have to say what their expenses are. And just as your lordship points out, national insurance, water, food, car, entertainment. And the judge does look at all of those factors. As you said, well, can't be entertainment. These are a mortgage. You have to prove it. All of that is presented to the court.
And is that in Justice Chandler's judgment? Can I find that in that analysis in his judgment?
Yes, in fact, I think Justice Chandler set out the financial statements.
No, the analysis. I'll look for it. Let's not detain ourselves.
But Mrs. Woodstock, to make a long story short, in the end,
the consent order, was it not?
The consent order was attacked, but in the end, the Court of Appeal said we dismissed the appeal. So, and whatever happened, that interim consent order was alive, certainly to 2019. And then the discussion or dispute was about how much money should be paid. A certain amount of money has been paid, but there is an amount of money of at least allegedly 273,000, where the other side has some concerns about that and says that could not be just enforced through a contempt order. So we don't have to go too much into the facts or the evidence, because that is behind us. I think even Mr. Weeks would agree with that. So,
yes.
So as a background, this was enough, but we get the picture. We take the point. So now coming back to yes, the issue that is more narrowly before us.
Except, my lord, I wanted to highlight that because one of the issues is the evidence, the beyond reasonable doubt, and it is important to highlight the period when Mr. Tatem said he had no money, and the evidence that was presented to the court. And one more thing on the background is to point out Justice Kentish's forthwith order that in between the hearing of Mr. Chandler, there was the time when Mrs. Tatem faced eviction, made an application. Justice Kentish did a forthwith order for payment. That was also taken to the Court of Appeal, and that was also dismissed. So I'm just underlining that Justice Chandler did a full review of the situation and the facts, it was dismissed by the Court of Appeal. Justice Kentish did her review, did a forthwith order, and that was dismissed. Now we come to the enforcement proceedings,
Correct.
my lord, which brings us to where we are. And with that background, we started the enforcement proceedings because notwithstanding Chandler, Kentish, and Court of Appeal orders, Mr. Tatem was making no payments. So the proceedings before Justice Worrell essentially started again. So despite all of that information, and what the record will also show, that it was documentary evidence before Justice Chandler, and I'm sorry, Justice Worrell, and that went on from 2017. So I have the record of appeal. So for Mr. Tatem, of course, is saying he has no money. And what Justice Worrell did is subpoena various places where he worked and again cover the evidence. So for example, the evidence of Rubis that he had been paid $329,000 gross. In any event, that was not disclosed until Justice Worrell requested that information. And that corresponds with a period where Mr. Tatem paid $500 for the entire year. There was discovery from Rubis, Record of Appeal 656, Gildan, Rotherley, Sheffett, all these different areas. And it's important to make these submissions. So for example, because this shows the period of time and it also shows the dishonesty. And that is relevant when we come to the ultimate decisions. Because while Mr. Tatem is saying he has no money, the discovery shows the opposite. And if your lordships look at the Record of Appeal, as I said, you would see the information that Justice Worrell went through. If you look at the order of the way the matter progressed, there's an order of Justice Worrell from the 10th of January 2019, which is at page 191 of the record, which shows him asking for information. There's another order for him of the 7th of March 2019 at page 194 of the Record of Appeal, again asking for the third-party evidence. And there is the record of these persons responding to the court on this information. So it is documentary information. It was not some disclosure from cross-examination. This is documentary evidence of his earnings. We are beyond reasonable doubt because there clearly was an order. There is an admission that it was not paid, and there is clear factual evidence of Mr. Tatem's earnings. So even if you want to discuss how much, etc., the point is he paid zero from 2015. Zero from 2015. And I want to stress to the court that this takes us beyond an argument of clearly he can pay. If you want to argue how much, then that's an argument. But when you are paying zero, that reflects something else. And the point is that in 2019, my lord, when Justice Worrell made his first order, so Mr. Justice Worrell had before him an application for enforcement. And part of the discovery was to determine where we can go. Under Rule 106 of the Family Law Act, that is the procedure to be followed when you are claiming a person has disobeyed an order. And that is the provision of the Family Law Act. And that is the provision that Justice Worrell followed. And Justice Worrell's first order was for him to pay the amount that Justice Kentish had ordered in 2013, $18,000. So Justice Worrell's in 2019 was for Mr. Tatem to pay the $18,000, which he then also an unless order. So he made that first payment in 5 years. So at no time from 2015 has Mr. Tatem made a voluntary payment in accordance with the order of the court, except for when Justice Worrell has ordered it. The first one was that amount. The second, and that's in the face of cold, hard evidence that he had money. The second order that Justice Worrell made was the payment of the 213. And again, as we would say, certainly Justice Worrell's findings when he went through this whole process. And it's amazing to Mrs. Tatem because I filed this, we did all of this, and I'm going through this again. Yes, we had to do that. So Justice Worrell made his decision on the 213. And as counsel pointed out, that was his calculation of the 2.4, which was the actual cash payment that was made. And that was appealed in number 8. My Lord, that appeal went first to the then Chief Justice Gibson. And he dismissed it as having no prospect of success. It then went to the full court, and that was dismissed as having no prospect of success. And on both occasions, Mr. Tatem's faced imprisonment. The point is nobody believed, and the evidence does not support that he could not pay. And of course, he did pay. So his application for a stay in number 8 was refused by the Chief Justice and refused by the full court. And he did apply to the CCJ for leave, which was not granted. Which brings us to the second order of the 16th, or the further order of the 16th of September, which is the 273,000. And that was the balance of the amount owed to 2019. And again, if the court looks at the record, there is the evidence of what Mrs. Tatem, there is a specific calculation, and there is the amounts that are shown as being owed. And the argument then was that it was not specific. Justice Worrell went and made the order that this could be enforced. So he appealed that order, and that's the number 24. He applied for the stay, and that stay was refused. And this is where he is asking this court to overturn the Court of Appeals decision to refuse that stay. The considerations of a stay are well known, and this court has set it out as well. We are looking at the prospects of success. And the considerations to overturn the Court of Appeals discretion is also well known. So I want to look at the grounds of appeal and the argument as to why this court should overturn the Court of Appeal. I think as was pointed out, the grounds counsel has put to this court. The first one was that the Court of Appeal ignored that appeal, and the appeal cannot be heard. He ignored the order that the appeal be heard as a matter of urgency, and that the appeal cannot be heard as a result of the failure to issue reasons. Our first point, as counsel accepts, is that the Court of Appeal did not ignore it, and they did write, and there are 2 orders, which we also put in the transcript, where the Court of Appeal ordered the registrar to ask for the transcripts. But we would say that the appeal is not heard because the appellant hasn't proceeded with its appeal. So it is not a question that it cannot be heard. We would disagree with that view. We've said in our submissions that certainly there can be no argument about the length of time and the delay in giving judgments, in giving reasons for judgments, in being able to have transcripts. And this court certainly has, when you look back, probably from the first case that came before this court in Merchant Valley, has repeatedly said these things are important. So nobody can argue with that. The point that is also repeatedly shown is that simply using the failure of the judicial system, which certainly Mrs. Tatum is not responsible for, is not a grounds, is not in and of itself a grounds that not to go ahead. The cases that counsel referred to in terms of English, I think as we point out in our response, says very clearly that an unsuccessful party should not upset a judgment on the grounds of the reasons, despite having the advantage. And I referred to the case of Blairmont Rice, also before that had been before the CCJ, which is making that same point. And Hughes and Hughes. And in fact,
Mrs. Woodstock-Riley, counsel, I'm following you very, very closely. Thank you for the cogency of your argument. This point bothers me a little though, because it seems to me that the CCJ gave an order which anticipated that there be the hearing of an appeal and suggested certain conditions, if you will, that would be useful in the hearing of that appeal, the reasons being given, and the transcripts and so on. That has not occurred, obviously.
Yes.
And I would like, therefore, for you to make me more comfortable with the idea that the stay of execution should be lifted in the absence of the appeal as contemplated by this court and as asked for by this court being heard. So could you help me a little further on that point, please? I know you have addressed it just now, but I'm a little concerned about it. Thank you.
The reasons that the transcript were requested as requested, my lord, but what was canvassed was that it was not necessary for the matter to go forward. And that certainly is what the authorities show us. And certainly
that is in face, I'm sorry, that is in face of the order of this court that the transcript be produced.
No, it wasn't the order of this court. It was the order of the Court of Appeal.
I see.
What this court said is that you should get ahead and do the case.
I see.
The Court of Appeal, in response to Weeks's submission, one of its orders, it's made it twice, was to write the registrar and say, produce the transcript, produce the reasons. It didn't say it could not go ahead without. And what was then canvassed is that, as counsel then pointed out, and I have that in my submission, he said it in number 8, and if you look, if he said it in number 13 of 2019, is that the issues in this matter can go ahead without reasons and transcripts. So you don't have to take my submissions. It's points of law that there is no reason for a delay. And I highlighted certain areas of the transcript, but in looking back more thoroughly through the transcripts, I came across where Justice President Narayan at the hearing from the 23rd of November, 2021, and that's at page 1138, had said, the parties we were discussing, can we hear the stay before? And he says, what are your views? What do the attorneys think? What are your views? And the response was that we can go ahead with the stay. So I don't see how you could now argue as a point that the Court of Appeal was at fault. Justice Narayan, if you go back to the 23rd of November, asked us what our views were. And Mr. Weeks himself said, yes, we can go ahead. And so he says this in February 2022, the 24th of February. You have also there, I didn't have it in my submissions, but it's at page 1155 of the Record of Appeal, where Justice Narayan says your grounds of appeal seem to be raising not an exercise of discretion, but issues of law. And that was agreed. And very important, at page 1157 of the record of appeal, Counsel Weeks says, look, this is a type of matter which we really don't necessarily need, what would normally need, where there was serious conflicts of fact or credibility. So you have the general principle that you must have reasons, you must have transcripts, you must go ahead. But everything is applied to the facts. And what we all agreed was that these were raising issues of law, and we could go ahead. So don't even take my word for it. Counsel Weeks says that. And certainly the Court of Appeal can't be faulted, and it can't be raised as a reason to this court that they proceeded to hear the stay without having the transcripts. That can't be possible. Actually, I think it was said in the CCJ case that you can't, having elected to progress the matter, the Blairmont case, counsel cannot now disavow the course. So counsel said, yes, let's get on with the stay. So you can't change your mind when you don't have a favorable result. And essentially, my lord, what the Court of Appeal decided after hearing the matter is that there was no prospect of success. So that's the Court of Appeal's decision. And again, and this is where I go through the history, you have an overwhelming history of earnings. You have an overwhelming history of dishonesty. You have findings of fact by Chandler Kentish Court of Appeal. And this is where, and by Worrell, and this is where we are. So certainly this is what is before the Caribbean Court of Justice. And whereas we certainly quite appropriately have issues with timing and so on of our court system, we still have to look at the facts of this particular case. And this is not one where it comes. There's no threat of Mr. Tatem going to jail. And the submission, and that takes, I think Justice Barra pointed out the grounds that were put to this court. So the ignoring the order and that it can't go ahead because of the failure of reasons, that must be dismissed. The other second ground was that there was insufficient or no importance to the effect of the order, which is the incarceration of the appellant. This court would have to say what evidence is before it that that is the effect of the order. What evidence? It can't be because counsel says so. So you have counsel saying so. You have Mr. Tatem saying, I can't pay. Mr. Tatem has said he can't pay from 2013. And the findings of fact consistently with documentary evidence is that he can earn, and he does earn. So this court would have to say the effect of the order is the incarceration. On what would this court determine that? Mr. Tatem says so, or the findings of the High Court and Court of Appeal of Barbados over several hearings. And I don't see how in the weight of that could be any authority. And if by some chance there is a consideration that there is a threat, if you go back to then Chief Justice Gibson, when he first heard the matter in number 8, as he pointed out at page 894 of the record, where he then said there is no prospect of success. He said, if it is that the applicant is going to be exposed to ruin, a significant basis for that ruin is the continual failure to make any payment at all. So if he is in prison, not having paid by Monday the 15th, that would be, is a direct result, in my respectful judgment, of his failure to make any payments. And I do want to correct something counsel said, that when it came before the Court of Appeal, Mr. Tatem was still facing imprisonment. He made a payment of the 213 after the Court of Appeal's decision. And that's also a matter of record. So Chief Justice Gibson and the Court of Appeal, aware that he faced in prison, pointed out there was no prospect of success. And again, we would say that's because of the overwhelming evidence and the failure of the arguments. The third ground that was put to this court was that there was no prospect of success in absence of the reasons and transcripts. And as already said, the absence of the reasons or transcripts cannot be used as an argument when you've already said it. But prospects of success is the essential basis that this court should look at. And when you go through the arguments in the appeal, the first point was the functus argument, which, again, we'd have to say what was clear was that there was a finding of contempt, and what was to be done, Justice Worrell made an order on what was not agreed, what was agreed, and then made a further order on the second amount, taking into account the information. That in 24 is completely new because it would not have arisen in number 8. The second and third points are of the grounds of appeal in 24 is that the order is lacking in sufficient particularity and proof of the amounts due and owing. Counsel indicates that that was not in the grounds of appeal in number 8. It was, however, submitted and raised in number 8. And that is in the record of appeal. And this is again why I have added in the additional documents, because counsel made, and in all of this, there's been very strong submissions and very lengthy submissions. Counsel made that very submission in number 8 at page 1097 of the record of appeal. Just pulled it up here. Paragraph 27, which is the point that the debtor must know the liability for which he's facing imprisonment, how much money is actually enforceable, and their argument that based on the wording of the order, $2,004 a month is what was payable, and the rest of the order is not specific enough for enforcement by the court. So the very argument was made in number 8 that is raised in number 24. And with regard to the proof of the amounts owing, as I said before, that was put in evidence before Justice Worrell. And again, it's important, I mean, this is such a huge and lengthy case. One really has to go back through it. But the evidence is there before the court. As my record says, it's page 114 of the record.
In what period of time was that evidence given? Long time ago, huh?
This was before Justice Worrell. But the ground of appeal was that Justice Worrell couldn't make the order because there was no evidence before him of what was due. And the point is there was evidence before Justice Worrell.
Yeah,
there was evidence of the 500,000.
You can have evidence of what was due, but I'm talking about the evidence that he was able to pay. That kind of evidence is pretty old, is it not?
Well, it was the evidence at the time Justice Worrell made it. So it can't be that we start the process every time.
No, but things change. Things change in the course of time, certainly in a 10 years period. So I'm just asking how fresh or old was that evidence?
Well, my lord, the evidence will be for Mr. Tatem to provide. Sorry, if for example he had a God forbid, an accident and could no longer work, that would be fresh evidence. But what the court, it cannot be that every time, first of all, that Mr. Tatem delays the matter, and every time we come to the court, we start the process again, which we are actually doing in the High Court. But Justice Chandler went through all of this and made his order. When we came to enforcement, we didn't use Justice Chandler's information. We gathered more information. It shows two things, and the capability of earning, and as I said, his dishonesty. So,
if I may, Counsel.
Sorry?
Counsel, if I may?
Yes.
As a matter of practice, in relation to the point raised by my brother, the chair, would it not be open to the husband in this case to make an application even now to say, I am making a fresh application to vary the order made by Justice Worrell or to vary the maintenance order? I put forward these indications. I have since that time, and in fact, I suffered in the year 2015 a double amputation, and I have not been able to work, and therefore that order is now oppressive, etc., etc. My question is quite simply, is it not, had things changed, or if things have changed, for somebody who is directed to make a payment, to ask the court to vary that order for payment? I know an application to vary the order was made in 2013, but the question is, can not an application be made again, a fresh application?
No, my lord, I would say not to go back over an order that was made, heard, evidence given. It would be relevant for an order going forward. But for any litigant, if a litigant goes to court, let's not speak about this matter, has an order made, certainly you can't say that that order then must be varied. It's money owed, and this is maintenance. This is maintenance. This is based on Mrs. Tatem and the daughter's needs. So I don't see how it would be, and we even, we're speaking about maintenance to 2019. It's not a money judgment. It's not money owed in abstract. This is food. This is medical bills. This is the child's education. In fact, the amount doesn't even take in education because she didn't go to university. She wasn't able to. So I think
you have answered me, Counsel. Thanks.
Thank you.
Yeah. Counsel, just to get it clear, you were saying that the evidence that was put before Justice Worrell on the contempt proceedings, that evidence was, I don't want to use the word fresh, but that was current evidence. Is that right? Evidence of his earnings, his means, his capacity to pay. So it wasn't that you were relying on 2013 evidence. Do I get you right on that?
Exactly. Exactly, my lady, we went through it again. And as I said, the evidence, and I think counsel admitted this, it wasn't, when he says proof of amounts due, it wasn't the amount due that was questionable, but whether it was recoverable. So there was proof of the amount that was due. The other issue raised was that of the presumption of innocence, and that he should be afforded that. And that was raised in number 8 as well as ground 5 in number 8. And again, Justice Worrell followed the procedure as in 106, where under the Family Law Act, and again, this is after gathering the evidence, where he raised, and it's not a question of cross-examination, the act requires that he ask if there is any reasons why he shouldn't be charged with contempt. So that was clearly, the Family Law Act was clearly followed. The Debtors Act, and that has been raised persistently by counsel in the High Court, in the Court of Appeal, and at every stage that has not been accepted. The Family Law Act provides for several different methods of enforcement, and the argument that it must be done under the Debtors Act certainly has no prospect of success in the face of the Family Law Act. And the issues with raising the Debtors Act is identical in 24 to that of number 8. Similarly, the other ground of appeal in 24 was that the length of time that had passed, you can't enforce arrears. That is identical to ground 2 in number 8. And that was already dismissed on the principle if that is relevant for someone who has sat on their rights, done nothing, and then come 7 years later and say, I want this money. That certainly could not be said from Mrs. Tatem, who from 2013, when he stopped paying, filed an application. If you look at Justice Chandler's order, he dealt with the variation and he said, no, we can deal with the enforcement aspect, and he gave an adjourned date for it. That, however, then came up before Justice Worrell. So the question of the length of time to enforce arrears does not arise in this case because Mrs. Tatem did not sit on her rights. And the final ground of appeal was that even if it's under the family law, that the court did not inquire as to whether she needed the money and did not inquire as to his current finances. And again, we're speaking about an enforcement of an order. So the issue of whether she needed it was what was dealt fully within the trial. There's no need at enforcement stage to prove that Mrs. Tatem needed the money, which of course she clearly did, because we have the medical evidence of her not being able to work. And there is, again, a plethora of evidence of Mr. Tatem's earnings during that period. It can't be that he now says, well, I don't have it, but the fact is you had it. So what, if he doesn't have it because he was flying around the world and went to Canawan 11, and certainly the evidence from the immigration is there.
Mr. Can you tell me, under section 106, what is the procedure, and did Mr.
Justice Tatem, you're back, yeah.
We didn't hear you, Justice Jamada.
No, I'm asking under section 106. The procedure for of the Family Law Act, the procedure for enforcement, you say that that's what Justice Worrell followed in both instances.
Yes.
And that provides for contempt, right? Finally.
Yes, my lord. It says 1064 is the application that you allege that somebody has willfully disobeyed the order. And 1067, when you are hearing the application, the court may act in accordance with Sub-Rule 2. Sub-Rule 2 deals with when you are before the court, you are asked to say why you shouldn't be held in contempt. So the matter started with an application under 1064. And the procedure is then outlined in 1067. And just to
and so what I'm asking is, so the procedure, was it voluntarily, in other words, was there voluntary participation by the appellant in this process?
Yes, my lord, and he was represented. So
yeah. And was any objection taken at that stage as to his involvement in the process?
Not to his taking the stand.
Yeah.
And even on the stand, he could say he's not answering.
So that's what I'm trying to ask. Did he, in other words, for example, did he say that I don't want to take the stand, but was compelled to take the stand? Did he take the stand and say, I don't want to answer a question, but was compelled to answer a question?
No, no, my lord.
No, right.
And he was represented by counsel.
Yeah.
And bear in mind again that we reached that after a period of time of discovery before we reach the stage to there. And one just to 1062, which is that he should inform him orally of the contempt with which he's charged, and he may require him to show cause why he should not be dealt with contempt. And I was essentially asking him, confirming with him the evidence Worrell had received of what the third parties had said.
So on your case is that the procedure in 102, 4, and particularly in 7 was followed in this before Justice Worrell.
Yes, my lord, 106.
Yeah, good. Yeah.
And that was an application from you.
Yes, my lord.
Correct. Okay.
And he had willfully disobeyed the decree, and just to confirm that under the Interpretation Act, the decree relates to an order, and Section 86 of the Family Law Act is what deals with the enforcement of decrees.
Okay, let me ask a question, and this has to do with my civilian background, because I think in the civil law we don't have contempt, just to understand the principle. So let's say that, and this is a theoretical point, let's say that Mr. Tatem was able to pay, but he didn't pay. And then there is a procedure for contempt, but at that point in time, he cannot pay. I'm not saying that that is the case, but but he clearly violated the order because he should have paid and he could have paid, but he didn't. But at this point in time, he actually cannot pay. Is it then possible to have an incarceration anyway? Because as I understand it, the contempt is a sort of criminal procedure. In the civil law, for example, there is no such thing, but you can ask to lock up somebody for some time if he is not paying, but only to force him to pay. If you know that he cannot pay, then you cannot, then a judge cannot impose that measure. So there is a difference in concepts. So what are you saying? If, for example, at the point of the enforcement proceedings, Mr. Tatem was not able to pay, I understand you're saying he was, but if he was not able to pay, would it then still make sense to lock him up for 28 days? Understand the question?
Yes, I do. And I would say yes, my lord. I mean, that is the...
Because it's a punishment.
This is what any ordinary person facing a situation would have. Mm-hmm. So where we have yesterday a lawyer before the court who had money given, and now he doesn't have it. Mm-hmm. You still got to be locked up.
So yeah, that's clearly a punishment.
It is a punishment.
Yeah.
And one, I go back though that there's no evidence. Before we get there, is that a threat? Is that a possibility? And it can't be just thrown out there as a bald assertion.
Okay, I understand.
And so I think Justice Barrow, if he had a double amputation last week, that may be something else. But the fact is we've shown he had the money. And I would use Chief Justice Gibson's point that if he can't pay, it is at his own doing.
Okay.
It is a result of his
own
action.
I understand the concept. Thank you.
And just to conclude, my lord, well, we stand on the submissions, but I think I have gone through the grounds of appeal in 2024 and shown why those had no prospect of success. And this is why the Court of Appeal, because that really is the starting point. This is why the Court of Appeal did not grant a stay. And just to conclude, I would say certainly this court has, and again, I would say rightly, certainly as an advocate, is strong on the issues of reasons and the time that has happened, but that counsel and litigants also have a part to play in the delivery of justice. And that needs to be considered. And I would think that the court or apex court would have a strong opposition on the respect of court's orders. It has to start with just simple respect before we have to go through all these procedures. And what I would ask this court to look at, which you have very clearly, is a complete disregard and disrespect for court's orders. You have the often quoted, the unqualified obligation of every person against whom an order is made to comply and obey until the order is discharged. But Lord, we have had 10 years of spectacular disobedience, and that cannot go unnoticed by this court. It must have some reference. It's an unusual case in family matters. She says, he says. In this matter, and Mrs. Tatem would have come to me and said, that building looks like his. Somebody told me he does this. I can't go to the court with that. I have to go to court with hard evidence. We get the hard evidence. Third-party discovery for years and years and years. Well, Lord, it's not a question of accepting what Mr. Tatem says or Mrs. Tatem. This is hard evidence. And I'd also like the court to look at the issue that throughout the court system in Barbados, they have recognized that this is a case of abuse, that this is litigation abuse. And I'm not saying that that is a matter. The reason for that is when you pay nothing. I want this court to actually look at that and determine whether it is me being emotional or it is a fact. So when you have a situation, and this court, when we've been before it before, has asked repeatedly, well, can't you pay something? Every court has asked that. Mm-hmm. And when you pay nothing, that's telling you something. That is telling you something. And abuse is more than a black eye and a broken bone. And that has been the finding of the Court of Appeal of Barbados, that Mr. Tatem is guilty of litigation abuse. And the other issue that it has been the finding of the Court of Appeal of Barbados, which is why they've prevented him from taking any further proceedings unless they got leave. Certainly, counsel submissions has been looking at the effect. And this court said it in Rodriguez as well, where you're balancing if we reach that stage, because our point is that there's no prospect of success. But there's the issue of Mr. Tatem and certainly his right to appeal, which he has exercised, and the question of the liberty of the subject for 28 days. Again, we're saying that it is not a threat, but even if it is, that is it. But somewhere in there, which counsel hasn't addressed, is then the balance. What's the effect on Mrs. Tatem? Katherine Tatem and Karina Tatem. So you have, and in Mrs. Tatem's case now, you're speaking about the life of the subject. Apart from the fact that she has breast cancer, she's been through this process in 10 years. And equally important, she came to the judicial system for assistance, and she has abided by it. And so my submissions are not, feel sorry for her, give her something, please. We're asking for the orders of the court to be respected and enforced. Mr. Tatem has had his day over and over again, and we're asking for the orders of the court to be respected. The effect when you're looking on the balance on Mrs. Tatem and Karina Tatem is stark. And I cannot see the situation where this apex court, where there is an order for Mr. Tatem from, when is it now? 2020, that he pay maintenance that is outstanding. So it's not just give her some money. This is maintenance. That Mrs. Tatem should be denied receiving that amount on this evidence.
Counsel, Counsel, are you hearing me?
Yes, yes.
Yes, I wanted to ask you a very practical question. I may have missed it, and it may be in the document somewhere, and I haven't noticed it. But if we were to be with you in your submissions, what is the date by which the Mr. Tatem ought to make payment or face the consequences mentioned by Justice Worrell? Because it can't now be what it was before. So yes.
And you will see before, although I think that transcript is not there, certainly before the Court of Appeal that was raised, and it would now take effect. It would not be unreasonable to give a period of time, I would say. But Mr. Tatem as well, it certainly should not be more than a month or 2 months, because Mr. Tatem should have been aware that this was the situation that he faced.
So you're saying a maximum of a couple of months?
At a maximum, my lord. Again, balancing it with that there are two people. This is not a case of the state and Mr. Tatem. Mrs. Tatem and Karina Tatem have been suffering for years. And they are entitled to the judgment of the court.
Thank you.
I certainly welcome any questions from the court.
Mrs. Woodstock, I only want to follow up on that question, and well, I must say I find you very generous. If the state refused, we've been in this court, Mr. Tatem has legal advisors. He knows that one of the risks of litigation is that this court can order refusal of the stay. That must be a well-known, long-known prospect. On what principle do you say we should continue, we should order, it'll have to be an interim stay or a further stay for 2 months or a month or something? Because it'll have to be in an order, right? The order would be the appeal is refused, the orders of the Court of Appeal are upheld, for example, but some adjective stay is granted for on or before sitting date. On what principle are you agreeing to that?
It would have to be that the order, Justice order was that he paid by Justice Worrell made it in September, and I think he ordered him to pay in March. So
March
the order could be.
2021.
Sorry?
Yes, you're right, March 2021, which is no longer possible.
It could be that he pays it by March 31st. Justice Narayan, when it was raised, said it would mean it is forthwith. And the reality is, even with it forthwith, we have to start a process even to get him arrested. Somebody wouldn't just go and pick him up. So we'd have to go back to court to get a warrant of arrest, etc. So he would still have time unofficially. So as I said, I'm guided by the court, and I agree that he should have been aware, and I'm confident that it would be paid.
Of course, there's always the risk that it is not paid and that he goes to jail for 28 days. That's also a possibility, correct?
Yes, yes.
Yes. So in that, in that case, it wouldn't make much sense. But anyway, it would be a punishment, as you say. So although that is not what you really want, you want him to pay.
Absolutely.
Correct.
And he has only made payments on this order from 2015 when there was an unless order.
And there was also a payment was made when this court ordered that he should pay 105,000.
Yes, yes.
And into the Court of Appeal, but that was paid directly to you, to your client, correct?
No, it was paid in, and then subsequently it was paid out, and that was in cost.
That was cost, huh? Yeah, that was for cost.
We're not even talking about the fact that he owes cost orders of over 300,000. This 273 is maintenance for Mrs. Tatem and Katherine Tatem.
Yes.
To 2019, only to 2019.
Only to 2019.
So, Ms. Woodford, let me ask you one other question theoretically. If it is that he goes to jail and spends the 28 days, doesn't pay, can you bring, as a question of law, contempt proceedings thereafter on the same, under section 106, the same info? In other words, he goes, he doesn't pay. He serves his time. Can you come back under 106 for enforcement and for committal again?
I don't see that we could for committal again, because he would have been punished for that contempt. He would still owe the money.
Yeah, of course. The debt is never extinguished until some court says so. But I'm talking about the 106 contempt. Having gone once and been punished once, you can't just keep bringing him back and perpetually repunishing him for the same debt, non-payment. Is that your view?
Yes, that's my view.
Yeah.
And again, we'd have the process, which we're doing now, because Mr. Tatum continues, and we've put it there that, as counsel indicated, we're in the discovery or process again, which would show what he's continuing to earn. But Mrs. Tatum is exhausted.
No. I've heard you. I'm fine, you know. I'm just trying to, just in my mind, to ask you what was your view on 106, whether you could come a second time for contempt.
I don't see that.
It's not relevant. It's not relevant to our discussion today. I was just asking you.
He would have been punished, but we would have to do further applications
for enforcement.
Along the same lines, counsel, there is no requirement, therefore, for him to purge his contempt. He just serves his time.
Yes, and that is something that bothered me, but certainly whether he couldn't have been held in prison until he had purged his contempt. But I do believe that there is a restriction that it is for a period of time. So certainly my option would have been if he stays there until, but that is not legally possible.
And you see that under the Family Law Act.
That would
I think it may be in the general law of contempt that yes. For civil contempts there are you can't have an open-ended imprisonment until you pay or purge.
Yes,
I may be wrong, but that's my recollection anyway. We could look at it. Yeah,
that's my understanding as well.
Thank you.
Okay. Is there anything else you wish to say, or I think you went into all the points that were made?
Yeah, nothing else unless there's any questions. I'd really like to reassure the court on any issues that arise in the matter.
Yes, I think our questions were answered. So
yes, sure. with your permission, if you're returning to Mr. Weeks, I would like to ask him the same question I last asked of counsel on the other side. If it is that this court was against you, Mr. Weeks, and your client had to make the payment that has been indicated, what period of time would you suggest you argue for as being a reasonable time within which the payment could be made? Bearing in mind that counsel on the other side has been more than generous, according to one of my brothers, by suggesting 2 months at the outside.
I backtracked on that, my lord. 1 month. 31st of March.
Mr. Weeks, you're muted, so.
Well, assuming that the court were to go against me, obviously I would be remiss in my duty not to ask for as much time as the court would be prepared to offer. And I couldn't see that the court could reasonably give more than 2 months at the outside. If it were minded to grant such an indulgence to Mr. Tatem, having found against him on the appeal, which is before the court. So 2 months, but just by way of reply to very brief reply to points made by my friend. Mr. Justice.
Sorry, Mr. Weeks, may I, before you do the reply, on the same point?
Yes, my lord.
Yeah? May I ask if you would consider that the price of a 2 months extension would be paid by your client undertaking within, let's say, a period of 2 weeks to make a payment of 10 or 20% to account of the debt? I mean, just to get something. Sorry?
My lord, I would be entirely in the court's hands. I couldn't see that that would be an unreasonable position for the court to take if it goes against us on the appeal. We would be entirely within the court's hands and discretion, and I think that would not be an unreasonable position for the court to take, quite frankly. If the appeal goes.
Thank you for your help, Mr. Weeks. Thanks.
Just 2 points by way of response. And through the court, Mr. President of the court, Mr. Justice Barrow had asked a question vis-a-vis whether it would not be possible for Mr. Tatem to apply for a variation of the existing order, which is still in place, of Mr. Chandler. In the current family law litigation, there is an application for the High Court to review what has happened, to look retroactively, because we take the position that it may very well be that Mrs. Tatem may have had access to monies during the period of time which has transpired over the last decade. We say that for a couple of reasons. One, as my friend is constantly and correctly, quite frankly, saying Mr. Tatem has paid nothing really in relation to the order for a very long time until he was ordered to do so by Mr. Worrell. So that begs the question, where did the money come from for Mrs. Tatem to pay rent and buy food and all that, those things during the interim? Now, it is a fact that when one looks at the judgment of Mr. Justice Chandler, Mr. Justice Chandler did in fact find as a fact that Mrs. Tatem did have access to a very large sum of money in a bank account in Canada.
Mr. Weeks, that is of no relevance as far as I can see to this appeal. Whether Mrs. Tatem had access to money or has access to money from whatever sources, this is the facts of this case, in a sense, are closed, subject to you reopening it in proceedings. There's an interim order that was made and we had enforceability. All that our brother asked you is, could he come to vary the order? The position in maintenance orders is the answer is yes. You can come at any point in time if there's a change in circumstances and upon fresh evidence to vary an order. But it is prospective. And that is well known and accepted, isn't it, Mr. Weeks?
No, my lord, not with respect.
No. All right.
Under the Family Law Act, we have a specific provision which provides the court with jurisdiction to look retroactively.
But you must invoke it, have you?
We have. That's what I'm
Well,
saying.
all right.
Good.
Well,
anyway, I'll pass on from that point, my lord.
You
I
prosecute
don't want to tarry
that.
there.
Yeah.
The other point, which I believe it was yourself, Mr. Justice Jamadar, and Mr. Justice Witt, who quizzed my friend on the procedure that was employed by Mr. Justice Worrell. I just want to remind the court that the rules, though, the Family Law Rules 1982, were amended in 2014 specifically to include, as it relates to the enforcement of maintenance orders, proceedings under the Debtors Act. So before the amendment of 2014, the Maintenance Act, the maintenance orders under the rules were only, strictly speaking, capable of being enforced by garnishment and the other two readily known methodologies. In 2014, there was an expressed amendment including the methodology under, and it actually says proceedings under the Debtors Act for the enforcement of maintenance orders. This is why I have been saying from the very beginning of the enforcement that the wrong procedure was being employed. Because the rules make provisions, specific express provisions in relation to maintenance orders, which are a form of money order, which is spoken to by the Debtors Act as the general law of Barbados. So I just wanted to remind the court that that fact of law is very important in determining whether or not the correct procedure and constitutional safeguards were actually employed in the enforcement proceedings. And with those very brief comments, I have nothing further for the court.
But okay. If I could just make one housekeeping point, which I forgot to mention, and I'm sure counsel would agree. In case the court is looking at number 8 and the appeal, the re-amended appeal filed the 8th of July was struck out. So the appeal that you are looking at that would have been before the court was the one of the 19th of June.
I agree. That's agreed.
So
okay.
Just, yeah.
Okay, thank you very much. I think we went through all the possible points that could be made. We will, of course, deliberate on the arguments that were brought forward, and in due time we will give a decision, and you will be notified when that will be. It certainly will not take as long as some of the decisions we are looking at, but we will do our best to do that thoroughly, but within a reasonable time. So thank you very much. And
the stay stays in place until your decision.
Well, I think it would not be proper to act on the order before we give a decision.
Much obliged, my lord. Thank you.
As the court pleases.
As the court pleases.
So, Madam Deputy Registrar, we can close off.
Yes, we can, Justice Witt, and thank you. Thank you, Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatli. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada, and thank you, counsel, for your patience today with all the technical difficulties, and the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you very much.
Cheers. Bye-bye.